showed up in her stead. Yes, I'm slightly surprised. I thought you would have just stayed seated because of the because you were just staying seated, but not everybody is interested in legal issues. But the topic that we'd like to talk about, in addition to legal requirements for the cool things that you're doing, i.e. Operating a blog, being a travel blogger or an influencer because you have people who follow you either on Instagram or elsewhere, and they appreciate your opinion. So this is Dr. Jonas Kahl, my colleague, lawyer for media law, and myself, Peter Hense, who is an expert in the field of IT law, information law, and data legislation. So let's get started and look at the issue. There is the Edelman Trust Barometer in 2017. They found out that 55% of respondents, I know statistics are always annoying, but 55% of respondents of, say, a social media page is more trustworthy than an ad. And this is quite interesting because we have a great surge of advertising, paid advertising, which isn't identified as advertising in the social media. So to a certain extent, there seems to be a perception gap here. Now, I'd like to pass the floor to Jonas, who's going to give you an example. What is this all about? Oh yes, this is a case that was very dominant in the yellow press last year. Maybe some of you have heard about it. There was an altercation in the home of the Bayern Munich soccer player Coman, and this shows you how far-reaching the impact of influencer marketing can be. The background for the altercation was the following. Both the soccer player Coman and his girlfriend are professional influencers and have a certain reach on Instagram. But as Coman's reach is slightly bigger than that of his girlfriend, she used his account to market her products on his account. The problem was her products were in direct competition with the products that he influenced and that he was cooperating with. So he lost his cooperation agreement because competitive products were advertised on his account. And this ended up in a brawl between the two of them that was very much highlighted in the yellow press. So nice example. Now, if you talk about legal issues of influencer marketing, you have to keep in mind that at the end of the day, we are talking about three different areas. On the one hand, the broadcasting treaty. This brings up the question, what does the broadcasting treaty have to do with influencers and Instagram? But the internet and telemedia and other things are also regulated in the broadcasting treaty. And the second is the telemedia legislation in Germany. The third is competition legislation. So one company is attacking the other because it believes that when it comes to influencer marketing, there are some identification problems, which is the main problem of influencer marketing, or that one influencer wants to legally act against another influencer because they believe that certain things aren't sufficiently labeled. Now, if you have problems in that case, there are imminent threats from three different groups. On the one hand, the legal media authorities or the media control authorities that are responsible for controlling and monitoring, for example, YouTube channels. They act against wrongly identified or mislabeled advertising content, and they can impose fines. The second threat comes from the side of associations, either consumers associations, corporate associations, or competitors associations, who also look at labels being carried out. And the third are the co-competitors that I already mentioned, the competitors, the companies that compete with your company or with the company that you're influencing for, and they can also demand formal warnings or written warnings. And these are the three threats that need to be kept in consideration. Let me make a brief remark. We are seeing this more and more. We are very much active in the field of fashion and luxury consumer goods, and the influencers don't like like each other all the time, and the time that you were able to move in a more or less legally non-regulated area as an influencer are gone. Those are times of the past. In travel, this is not so much the case, but when it comes to luxury consumption goods or luxury consumer goods and food products, this is a different story. Yes, the times where we were able to say this is a gray zone, you can do whatever you want, these times are over. Since this case, I don't know if you know who this person is. It's Flying Uwe. Last year, he immediately was given another nickname, namely the Sneaking Creepy Uwe, and the state media authorities used him as an example. The case was or is that they tried to solve two issues. First, can providers of YouTube clips, i.e. YouTube stars, can they be official broadcasters? This is quite strange, but as the broadcasting treaty says that the broadcasting legislation applies if something is like a television station or a television channel, then it might be quite correct that the providers of YouTube videos, if they do it professionally, need to have a broadcasting license. And the second question is, if you believe that they are official broadcasters, then the question is, what is the impact of this with regard to labeling advertising? Advertising needs to be labeled and clearly identified when you do television, but on the internet, this is an entirely different story. It's a lot more stricter on YouTube than on Instagram, Facebook, and other social media. But this is a question that was to be dealt with in this these legal proceedings, and the state media authorities believe that Flying Uwe has to characterize and label his clips and shows as permanent broadcasting, as permanent advertising broadcasting, because the main purpose of his video channel was to broadcast his products and the products influenced by him, and there's a commercial interest behind it, so everything is a permanent advertising show. I just mentioned the legal requirements, but we don't want to bore you with too many paragraphs and legal talk, and that's why the three legal principles that are important, irrespective of whether we're talking about competitive law or the state broadcasting treaty, are applicable. First, advertising has to be clearly recognizable. You have to be able to differentiate between content and advertising. This clear recognition can be guaranteed, for example, by having a clear separation. And depending on the medium that you are working in, this separation has to be both spatial, visually, if we're talking about visual media, and as far as content is concerned. And thirdly, you have to also indicate that it is advertising, that it's a commercial or a special post. Now, when we are talking about identifying advertising, we are frequently using the buzzword product placement and surreptitious advertising. A classic example of surreptitious advertising can be seen right here. Ivanka Trump, in her function, if you may call it that, as first daughter, right after the inauguration of her father, she gave an interview in the American media and wore this bracelet. Now, nobody was really thinking a lot about this, but just after the interview, this bracelet was sold on her online store, because in addition to being first daughter, she's also a jewelry designer and sells that jewelry, and that bracelet was sold on her channel, and we were able to see that she only wore the bracelet during the interview to present her own product and advertise them. And this is a classic case of hidden advertisement, surreptitious advertisement, that if you want to differentiate this from product placement, you have to first say product placement is a subcategory of hidden advertising. Product placement doesn't necessarily have to be illegal. Under certain conditions, it can be applicable and permissible. And these conditions include, for example, that the product which is being placed doesn't intervene too much in the script of a movie, for example, but that the product is just placed in a certain story. Next criterion, the product cannot be advertised as home shopping channels, for example, do. There cannot be any purchasing recommendations made. And the third criterion that needs to be fulfilled so that product placement is permissible is that the product isn't pushed too much into the limelight. And if you take these three criteria, and what do you think here? Is this an example of permissible or product placement? This is a case that was decided before the administrative court in Hanover. One person thinks that it's a permissible case, and the administrative court of Hanover said it is not permissible, and for various reasons. Well, first and foremost, because all of the three criteria are being violated. The product, if you know the chocolate bar pickup, you see that this is tremendously big. It is featured very dominantly. It was included in the actual script because the pickup bar was the reward for some test that the person had to do. So the only criterion that wasn't fulfilled was the purchasing recommendation. That was not made verbally, but I think in the ensuing commercial, it was also recommended to purchase this product. So a case that was not permissible. Another case that was in the media last year was Rossmann, the drugstore, and the way Rossmann influencers dealt with the requirement of labeling. The higher court of Celle said labeling advertisement isn't enough to hide a brief identification ad as a hashtag. The financial court of Celle said the hashtag ad is being lost between all the other hashtags, and it's not clearly recognizable at first glance that this is actually advertising. And that's the criterion. It needs to be characterized, it needs to be labeled as advertising. So you could almost say here that the hashtag ad needs to be put at the beginning of the post. It shouldn't be hidden in a hashtag that it's an advertisement. It needs to be clearly recognizable and identifiable. Another case which the courts in Berlin decided as late as October of last year referred also to an Instagram posting. That was the Superior Court of Justice in Berlin. The influencer in an Instagram story included a link, and the link was a link to the page that advertised the product that she presented in the respective photograph, and then you could go and buy the product under that link, and it wasn't sufficiently characterized and identified as advertising. So the Superior Court of Justice in Berlin said that this is unidentified advertising, and as such a violation of the legislation. Well, if you don't sufficiently label advertising, and if you use certain terms without really thinking about them, so for example, if you use the hashtag detox and post and tweet or share something, then you have to be aware of the fact that as soon as you link this to some commercial ideas, i.e. product placement or affiliate links, then you have to be careful to not fall under the realm of health advertising. And in this case, it was the case that if you use a hashtag detox for a drink, which isn't proven that it is a claim according to the health claim regulation, you cannot use it. Otherwise, the consumers associations will probably demand a written warning and a warning notice, and then this can lead to up to 800 to 1,000 euros of a fine as a reprimand. And here the United States is a lot faster. During her pregnancy, Kim Kardashian used a painkiller that she advertised and didn't clearly state that it was product placement or hidden advertising according to FDC criteria and FDA, sorry. And the FDA, as the regulatory body for health and medicinal products, in that case said, as administrative measure, we require a corrective ad from you. And she said, hashtag corrective ad. I guess you saw the attention my last morning sickness post received. So quite interesting. So she's trying to, again, balance the chaos that developed, or she tried to overcome the misunderstanding. Now, let me give you a brief best of the most frequent mistakes made in influencer postings. Get rid of the hashtag ad. It is not enough. And if you use a hashtag, even if you call it ad or advertising, it shouldn't be lost. It needs to be predominantly set at the beginning. Then product placement, wrong labeling, wrong indication. Don't have... If you don't label it as an advertising clip, but the only thing you do is advertise one specific product, for example, like the Pringle challenges or other things, make everything more complicated. Next thing, if you use third-party pictures, text, videos, or brands, nice example, you have to really think about if you act commercially, if you pretend to be an influencer, or if you are an influencer, then there are certain rules of the game that you need to follow, and they apply whether you're 16 or 60. And the same applies to misunderstandings arising from the fact that you don't differentiate between private and professional. Everything that's not merely private is professional. As soon as you're being paid for influencing a company, as soon as you get money for using a product, for placing a product, it's a professional thing that you do. And if you take a celebrity selfie and promote a certain product with that, you also run the risk that the personal rights of the celebrity are being infringed. That's not really pleasant. As far as personalities and personal legislation is concerned, thousands of hashtags were registered as brands. Spinning, for example, is a brand. So if you advertise fitness products and clothes, for example, and use the hashtag spinning because you believe that spinning is a mere activity on a bike, no, it's a brand that you're not allowed to use if you don't advertise products from, I think, Mad Dog Athletics, the same Love Travels. Who of you knows that Love Travels is a Marriott brand? You cannot advertise any other traveling products under Love Travels because it's a Marriott brand. Now, this is a case which was very much in the media last year. This White Moose Cafe, which has 195,000 subscribers and cafes for this little and subscribers for this little cafe. The owner said, "I always get these bad emails. Hi there, can I spend a night for free? I'm so much of a celebrity. I have almost 500,000 of followers on YouTube." At the end of the day, the cafe ended up becoming popular. The cafe, the hotel became popular. The influencer became more and more popular. Everybody has seen her somewhere, and both of them had an advantage from this. But let me give you a piece of advice. Christine Neumann, Chief Happiness Executive at Boutique Hotel, says, if you are influencer, if you are a blogger, please at least include a personalized address in mails. Otherwise, they are being deleted immediately. Now, this brings me back to Jonas. Jonas, over to you. Now, if we were to summarize, if it is supposed to be good for influencers and for the companies, mostly hotels that are being advertised, if you want to have a win-win situation and have a campaign that's really nicely identified and labeled, you should look at the corresponding influencer treaties that exist, and the following things have to be taken into consideration. First, you need to clearly stipulate how whatever you're doing is labeled and who's responsible for it. Is it the agency? Is it the company? Is it the influencer? Then you should look at who you are precisely cooperating with. This is a matter of trust and image. Does the influencer really go nicely with the company? Does the company go nicely with the influencer? Is it a match? And then you have to have clear rules. When does the campaign start? When does the campaign end? You can also determine when certain postings should be published and when not. Another issue which is always underestimated is occupational law and the youth protection legislation. If a company decides to work with influencers who are under 18, you need to get the consent of the parents, and all of these issues need to be dealt with the parents, as complicated as this might be. And working times. Yes, liability is another issue which is always important. Liability is always complicated, nonetheless an issue that needs to be dealt with because it includes all the mistakes that can be made. For example, copyright infringements, competition legislation, brand legislation, etc. Everything that can go wrong needs to be dealt with for matters of liability. And in case of doubt, the respective issues need to be included. You could also think of a dynamic payment, a dynamic salary, so you don't determine from the offset how much money can be made by the influencer, but that this is rather much based on the success of the campaign and the reach which is generated. And now we're coming full circle. Last issue, this brings me back to the first example of the soccer player Coman. You need to also include certain breakup clauses, i.e. reasons for which you can terminate the agreement early. For example, if on one account competing products are advertised and campaigns are made for competing companies, this could be a breakup clause. Now let's do some advertising for us. Look at your YouTube app on your cell phone, because we as a law firm have our own YouTube channel called Evil Legal, where in short 2-3 minute videos we answer questions regarding influencer marketing, or also copyright, data protection issues are explained in short explanatory video clips by us. So that might be of interest for some of you. And we also have 1.5 minutes to answer questions now. So shoot. And please use microphones, otherwise the questions cannot be translated. I have a blog which is a tourism blog, corporate tourism, and I used to live in London and started my blog in London. Now I live in Germany. And everything that you have just talked about, is that applicable for German law or international law? Or what about if I work with international companies and brands? Yes, that's always a problem. And at the end of the day, it depends on the target group or the country your blog is directed at, your campaign is directed at. And if you want to reach German-speaking audiences with your blog or your channel, you need to follow the German rules. I also have German readers, but my blog is in English, for example. That does not matter. It depends on the target group. In Germany, you also have people who speak English, and as soon as you target them, you're also bound by the law of the respective country. If you address an audience in California, you'd also be subject to certain advertising restrictions with regard to minors. You cannot, for example, advertise dieting pills. You'd be subject to that regulation irrespective of where you're located. Okay, so thank you very much. And if you have questions, I have seen some of you indicating that you had a question. We can do this on a one-to-one basis. Thank you.